The Supreme Court has just detonated a legal payload that changes the map of the American Republic. By a vote of 6-3, the High Court has not merely issued a ruling, they have initiated a regime change. This is a total reset of the Second Amendment landscape. If you carry a weapon, if you train for defense, or if you simply believe the Constitution is not a suggestion, you need to understand that the world you lived in yesterday is gone. This 6-3 decision has redrawn the boundaries of state power and rewritten the rules of engagement for your rights. From concealed carry permitting to the training bureaucracy, from background check delays to the concept of constitutional carry itself, the entire framework of control has shifted overnight. This is not politics. This is operational legal reality. It affects every single gun owner in all 50 states. Do not turn away. We are about to walk through the 10 new commandments that now define the future of the Second Amendment. Because what you do not know is exactly what the state will use to trap you. The court's 6-3 ruling sent a shockwave through the spine of the gun control apparatus. The case hinged on a single brutal question. Can the state force a law-abiding citizen to prove a special need to a bureaucrat before exercising a fundamental right? Can they force you to endure endless administrative delays? The court's answer was a definitive no. In doing so, they have weaponized the 2022 Bruen precedent. Every gun regulation must now face the firing squad of America's historical tradition. The decision has effectively installed constitutional carry as the national baseline for lawful citizens. Any statute demanding you justify your personal necessity is now legally toxic. The court has reinstated historical practice as the only valid test for legitimacy. The era of the permission slip is ending. The Supreme Court has reminded every state government that the Second Amendment is equal in firepower to the First and the Fourth. It is not a conditional privilege to be granted. It is a permanent guarantee to be enforced. Before this ruling, regimes like California, New York, and New Jersey operated under may-issue systems, feudal fiefdoms where local officials held absolute power. You could pass every background check, pay every fee, and complete every training hour, and a local sheriff could still deny you based on a whim. That era is over. This ruling dismantles the discretionary power that allowed officials to pick winners and losers. New York's good cause requirement has been obliterated. California's sheriff approval model is now legally indefensible. Hawaii and Maryland's restrictive schemes are facing immediate dismantling. The courts are now bound by historical analogs, not modern political bias. States that cling to these subjective systems are staring down the barrel of a legal countdown. They must rewrite their laws or face federal liquidation. For gun owners, this means your rights no longer depend on your zip code or the opinion of a local bureaucrat. For decades, anti-gun administrations used time itself as a weapon. They couldn't ban the permit, so they stretched the approval process into months or years to demoralize you. That strategy is now under constitutional fire. The court has ruled that the right to carry is active and immediate. It is not something that can be postponed by administrative incompetence. Excessive processing delays are now viewed as direct violations of the right to bear arms. States that drag applications out for 6 months are inviting federal injunctions. Lawsuits in Illinois and Massachusetts are already moving. Judges are fast-tracking compliance orders. The clock has become the new battleground. Every day a lawful citizen is kept waiting is now legally defined as a day of rights denied. And that will not stand. Training is essential for survival, but the government has long used mandatory courses and exorbitant fees as hidden taxes on your rights. The Supreme Court has examined whether these financial and logistical barriers can legally restrict access to the Second Amendment, and they have signaled that the game is up. Modern training mandates are being tested against the founding era, and they are failing. Courts are rejecting laws that have no 18th or 19th century equivalent. States like Maryland, Connecticut, and California are under direct scrutiny. High costs, excessive hour requirements, and multi-week classes are being challenged as unconstitutional hurdles. This does not mean training loses value. It means the government cannot transform instruction into an obstacle course. Responsible ownership is a personal duty, not a state-imposed toll booth. The ruling did not abolish background checks, but it placed a chokehold on how they are used. The court made it clear. The process must be fast, accurate, and non-punitive. Delays caused by technical errors or indefinite pending statuses are now constitutional violations. NICS checks that drag beyond 3 business days are under review. States that layer additional, redundant screening systems are facing legal challenges. Gun store holds based on vague suspicion are now legally radioactive. Waiting period extensions in states like California and Washington are being marked for deletion. The message from the court is brutal and simple. The system must verify disqualification immediately or get out of the way. Justice delayed is now rights denied. For decades, the state has relied on mandatory training statutes to artificially limit the pool of concealed carry holders. But this Supreme Court ruling has shattered that foundation. The court has clarified that excessive prerequisites, even those disguised as safety measures, cannot stand when they function as a burden on a constitutional right. Regimes like Maryland and New York, which currently demand up to 16 hours of instruction and live-fire demonstrations, are now legally exposed. These are not safety standards, they are barriers to entry. California's labyrinth of multiple classes, renewals, and in-person certifications is facing imminent rollback. The courts are now reviewing whether training can only be recommended, not required. The new legal standard demands that any precondition must have a clear historical foundation in 1791. This decision does not devalue training. It rejects the weaponization of training as a gatekeeping tool. The right to self-defense cannot depend on a class schedule or a $1,000 course fee. The message is absolute. The Constitution does not wait for a permission slip. This ruling has reignited the volatile debate over background checks. The court did not strike them down immediately, but they have fundamentally redefined how they must operate. The question is no longer about safety, but whether modern background systems, often slow, duplicated, and politically compromised, have any grounding in historical precedent. The justices noted a critical fact. The founders never required citizens to pass government screening before exercising a right. Extended waiting periods that delay lawful purchases are now being viewed as unconstitutional burdens. States that stack multiple overlapping checks are facing lawsuits for redundancy and obstruction. Federal waiting period policies could face review if courts determine they delay lawful access without evidence of public benefit. This marks the beginning of a wider legal offensive. Gun rights attorneys are preparing arguments that these systems have evolved into instruments of delay rather than safety. The court has handed them the weapon they need to dismantle that reality. One of the most explosive constitutional questions raised is about jurisdiction. When state laws contradict the Second Amendment, who has the final word? The court's majority made the answer definitive. Constitutional rights are national. They do not evaporate at state borders. States that continue to enforce restrictive gun laws are risking immediate federal injunctions. The federal courts are prioritizing challenges to conflicting state statutes under this new precedent. Even federal agencies, including the ATF, are being evaluated through the same historical tradition lens established by the Bruen line of rulings. Any government entity, state or federal, that attempts to narrow the Second Amendment will face strict scrutiny moving forward. This is more than a power shift. It is a constitutional rebalancing. For decades, states like California, New York, and New Jersey have tested the limits of regulation. Now, those same states are finding the federal judiciary standing firmly in their path. The 2022 Bruen decision was a turning point, but this new ruling transforms it from a precedent into an absolute doctrine. Every Second Amendment case going forward will now begin and end with the Bruen test. Does the law align with America's historical tradition of firearm ownership? The ruling strengthens Bruen by making historical justification a mandatory requirement. States can no longer defend laws based on modern fears, crime rates, or political arguments. Courts must now look directly to the original understanding of the Second Amendment. The result is a higher legal bar that will invalidate countless restrictive laws nationwide. This decision has effectively created a new era of constitutional analysis. Bruen is no longer just a standard, it is the backbone of judicial review. Any modern rule that lacks direct historical roots will struggle to survive. The balance of power has shifted permanently toward the individual citizen. The impact of this ruling will not stop in the courtroom. It will ripple through legislatures, agencies, and advocacy groups across the country. The conversation has moved from if we can challenge these laws to how far we can go. Lawsuits have already been filed in more than a dozen states using this decision as their foundation. Pro-Second Amendment states are moving rapidly to expand permitless carry and preemption laws. Gun control states are scrambling, looking for new strategies that can withstand constitutional challenge. The ATF's future actions, especially on classifications and enforcement, will now be watched closely under this stronger standard. This ruling is not the end of the fight. It is the beginning of a long campaign to rebuild the meaning of the Second Amendment under its true original form. The Supreme Court has drawn the line. The next battles will determine who has the resolve to defend it. the fight has only begun. The Supreme Court has spoken. Rights do not wait for approval, and the government no longer holds the presumption of authority. It must now prove its case. For decades, lawful gun owners have been on the defensive, responding to new laws and restrictions one by one. But today, the ground has shifted. If you believe in real reporting, verified legal updates, and a deeper understanding of the laws that shape your freedoms,